this time, will the attorney coaches and teacher sponsors identify themselves for the respective teams?
Good morning, Your Honor. Robin Fox, teacher coach for the prosecution.
Good morning, Your Honor. James R. Rico, attorney coach for the prosecution.
Thank you very much.
Good morning, Your Honor. My name is Eric Burrows, teacher coach for San Marcos High School.
Good morning, Your Honor. My name is Josh Webb. I am an attorney coach with San Marcos defense team.
And will the prosecution introduce themselves, please?
Good morning, Your Honor. My name is Caitlin DiMantova, Deputy District Attorney on behalf of the people of the state of California. This morning, I will be presenting the pretrial statement.
Good morning, Your Honor. My name is Kimya Saidi, Deputy District Attorney on behalf of the people of the state of California. This morning, I will be conducting the direct examinations of Alex Palmer and Dr. Francis Stone, in addition to the cross-examinations of Dr. Pat Choy and Brook Martini. I will also be presenting the opening statement this morning.
Good morning, Your Honor. My name is Rachel Miller-Ziegler, Deputy District Attorney on behalf of the people of the state of California. Today, I will be conducting the direct examinations of Detective Elliot Green and Toby Keaton, as well as the cross-examinations of Stevie Rico and the defendant, Jess Markson. I will also be conducting the closing argument for the prosecution. At this time, may our witnesses introduce themselves in the order in which they will testify?
Yes, indeed. Thank you, counsel.
Good morning, Your Honor. My name is Candace Adelbert, and I am Alex Palmer.
Good morning, Your Honor. My name is Davey Reedon, and I am Toby Keaton.
Good morning, Your Honor. My name is Will Penny, and I am Detective Elliot Green.
Good morning, Your Honor. My name is Juliana Eady. I am Dr. Francis Stone. At this time, may our clerk please introduce herself?
Yes, that'd be a good idea. Thank you.
Good morning, Your Honor. My name is Erin Schaefer, and today I'll be assisting you as court clerk.
Thank you, Ms. Schaefer. Will the defense team please identify themselves for the record?
Yes, Your Honor, and good morning. My name is Ian Goodstein, counsel for Jess Markson, and it is truly my honor to introduce the San Marcos defense mock trial team. I will be conducting the direct examination of Brook Martini and the cross-examination of Toby Keaton. I also have the honor of presenting the closing argument on behalf of Jess Markson. At this time, may my co-counsel please introduce themselves?
Yes.
Thank you, Your Honor.
Good morning, Your Honor. My name is Kimberly Young, counsel for Jess Markson. Today I will be conducting the direct examinations of Dr. Pat Choy and Stevie Rico. I will also be cross-examining Dr. Francis Stone and Detective Elliot Green.
Good morning, Your Honor. My name is Patrick McKenzie, counsel for Jess Markson. Today I have the honor of presenting the opening statement, as well as conducting the direct examination of Jess Markson and the cross-examination of Alex Palmer. At this time, may our pretrial attorney please introduce herself?
Yes.
Good morning, Your Honor. My name is Sarah Barkley, counsel for Ms. Jess Markson. Today I have the honor of presenting the pretrial motion. At this time, may our witnesses please introduce themselves?
Yes.
Good morning, Your Honor. My name is Sarah Hart, and I will be portraying Jess Markson.
Good morning, Your Honor. My name is Andrea Matthews, and I will be portraying Dr. Pat Choy.
Good morning, Your Honor. My name is Chantel Braley, and I will be portraying Brook Martini.
Good morning, Your Honor. My name is Danny Castellanos, and I will be portraying Stevie Rico. At this time, may our bailiff please introduce herself?
Yes.
Good morning, Your Honor. My name is Melinda Vogel, and I will be the bailiff and unofficial timekeeper. May I please introduce our courtroom artist, Chelsea Ward?
Yes. Thank you.
Thank you.
Do you have another artist here as well? There's just one artist? Just one. Thank you. All right. All right. Calling the matter of People versus Jess Markson. Counsel having identified themselves for record, my file here shows that there's been a motion to suppress filed by the defense. I'll hear argument at this point. I've read the pleadings.
Yes, Your Honor. Once again, my name is Sarah Barkley, counsel for Ms. Jess Markson. The defense moves that the script Murder by Monoxide be excluded from trial on the grounds that it was obtained through an unconstitutional search for which no warrant was issued nor proper consent given. May I proceed?
Yes.
The Fourth Amendment to the United States Constitution grants all individuals the right to be secure against any unreasonable search or seizure. A reasonable search is defined as one which is authorized by a warrant or consented to by an individual with authority. The search in question was unreasonable, in that Detective Green failed to obtain a warrant or any form of proper consent prior to searching the storage room in which the script was found. Upon arriving at Jess Markson's residence on October 13th, Detective Green contacted Miss Markson and asked if he could, quote, look around the estate. She did not consent. Instead, she specifically stated, you may search the house and the garage.
That's consent, isn't it? That sounds so much like consent. Wouldn't you agree?
Yes.
Oh, go ahead. Search the house. Search the garage. Well, what's the problem with that? You're
Well,
talking about an estate here, aren't you? An enclosed estate? You're not talking about a parcel of property in Hollywood. You are, but you're not talking about that property as well as some other property in, say, Riverside or San Bernardino counties, right? So isn't that consent?
Well, Your Honor, it was consent to search the house and the garage. Nothing more, though. From where the conversation took place, these were the only two buildings that were visible to Detective Green. And because Miss Markson specifically said, you may search the house and the garage in answer to his question, she consented to only a search of these. Now, the storage room and pool house were located 35 feet behind the main house and were not even visible. Therefore, the consent given by Miss Markson could only reasonably extend to the house and garage.
Well, how reasonable is it? I mean, the facts show that the defendant is waving his arms, right? And I believe further that the testimony is that it was rather casual, right? So we're
Yes.
talking about reasonableness here, are we not?
Yes, we are talking about reasonableness. And because Jess Markson, even if she waved her arm in an ambiguous manner, the only buildings that were visible were the house and the garage. Therefore, Detective Green, acting on an objectively reasonable basis, could only take this wave to include these two buildings. Now, when Detective Green discovered that there was a storage room and pool house behind the Markson residence, he should have contacted Miss Markson and verified consent to this area. However, he failed to do this, Your Honor.
Well, what does that have to do with this particular proceeding? I mean, that's a fact, certainly, and that's something that could have happened, but it didn't, all right? So being restricted to these facts here, all right, and looking at overall the conduct of the defendant here, wouldn't you say that at least a reasonable person, a reasonable officer in this particular situation would say, well, I've got the authority here to do whatever I want in terms of searching the various buildings on the estate, and your claim is no.
That's correct, Your Honor. Because Miss Markson gave specific consent to these two buildings, it would have infringed upon her Fourth Amendment rights to conduct a search not consented to. Because Detective Green entered the storage room and searched through Miss Markson's personal property to which she had a reasonable expectation of privacy, then that was infringing upon her Fourth Amendment rights. May I proceed?
Yes.
The Fourth Amendment secures these rights to individuals, and Detective Green clearly violated them when he interpreted Miss Markson's spoken statement and specific hand gestures to extend to her pool house. Now, the standard which must be met is established in the case of Florida v. Jimeno and requires that all interpretations be made on an objectively reasonable basis. The only objectively reasonable interpretation of Miss Markson's consent was that it did not extend beyond the main house and garage to the pool house and pool house storage room. Now, Detective Green has also stated that he received consent from Alex Palmer, a maintenance worker on the Markson estate. Even assuming that he did receive this consent, an individual must have both joint access and joint control, or appearance thereof, as in Illinois v. Rodriguez, to consent to a search.
Didn't you have that here?
No, we did not. In Illinois v. Rodriguez, a woman named Gail gave consent to search an apartment to which she referred to as our apartment. She opened the apartment with a key and let detectives in. Inside the apartment were her personal belongings. Now, Alex Palmer, on the other hand, told Detective Green, feel free to search my place, but I have not got a key to the storage room. You'll have to get that from Jess. There was also a locked door which separated Alex Palmer's residence from the storage room, to which Alex Palmer did not have a key. Now, Your Honor, it is clear that Alex Palmer did not have the same appearance of authority as the woman in Illinois v. Rodriguez.
Yes, but he had access to the storage room, didn't he?
Even if Alex Palmer had access to the storage room for the purpose of performing pool maintenance duties, that would not be enough to consent to a search. Stoner v. California holds that although an employee can enter an area to perform his or her said duties, they cannot consent to a police search of that area. Furthermore, Alex Palmer did not have joint access and control. Ms. Palmer retained the key to the storage room, and Alex Palmer had to get the key from her when she wanted to enter the storage room.
What difference does that make? I mean, that might affect the degree of access, but it certainly doesn't affect whether or not he had access.
That is true. However, the case of U.S. v. Matlock holds that a person must have joint access and joint control. Clearly, Alex Palmer did not have the same access and control as Jess Markson did, as she retained authority over the storage room. The storage room was not a common area to Alex Palmer and Jess Markson, because Alex Palmer was not a co-occupant of that area. Alex Palmer was merely a tenant of the apartment next to the storage room and had no jurisdiction over the storage room itself. May I proceed?
Yes.
Alex Palmer was not an owner, a lessee, or a tenant of the storage room, as in Von Eichelberger v. U.S. And when Detective Green entered the storage room, it should have been evident that it contained Jess Markson's personal possessions and papers. It was not reasonably an area which Ms. Palmer would have authority over. Now, even if Ms. Palmer did enter this area on certain occasions, this was not enough authority to give her the ability to consent to a search of that area. Now, Detective Green further compounded his error when he rifled through Miss Markson's personal stack of scripts. He conducted a second search, which was not consented to and which was unconstitutional. Jess Markson's alleged consent could not reasonably extend to this stack of scripts, and Alex Palmer had no authority to waive Miss Markson's reasonable expectation of privacy held in her personal stack of scripts.
Does your client have a reasonable expectation of privacy in personal items that are accessible to someone who's not a member of her family or that sort of thing? I mean, this person's a hired hand, right?
Yeah.
Gardener, does odd things around the house. Odd jobs, excuse me. So is it reasonable then to expect that those things would be private, even though they're quote personal? Obviously, they're papers and things of that nature, but is it really all that private?
Yes, it is. Now, Your Honor, because Miss Markson retained authority over the storage room, it was only reasonable to assume that she still held a reasonable expectation of privacy. And as the case of Cat states, any search is a governmental intrusion into an area in which someone has a reasonable expectation of privacy. Now, Ms. Markson did not waive her reasonable expectation of privacy, as in the case of U.S. v. Jenkins. Now, in this case, a man gave his sister a briefcase, and she retained sole control and access to that briefcase. Now, by giving her the briefcase, he assumed the risk that she could consent to a search. However, this was not the case of Miss Markson. Because Alex Palmer had to get access from Jess Markson, and because there was that locked door which separated her residence from the Markson storage room, Miss Markson still retained her reasonable expectation of privacy and authority over her personal possessions within the storage room. May I proceed?
Yes.
Now, Your Honor, today, if we rule that this search was constitutional, it will not be in the spirit of the Fourth Amendment. We must protect a citizen's individual civil rights, and it is the object of the officer to make sure that any search conducted is constitutional. Because this was a warrantless search, Detective Green should have ensured that there was consent given on the party with authority. Miss Markson, the sole person with authority and control over the storage room, never consented to the searches in question. And Alex Palmer did not have the authority or appearance thereof to consent to either of these searches. The defense respectfully requests that the script murder by monoxide be excluded from trial on these grounds. Thank you, Your Honor.
Thank you. Prosecution have anything to say about this?
Your Honor, the prosecution requests that you deny the defense's motion to suppress the evidence obtained from the October 13th search for the following 3 constitutional reasons. First, the scope of the defendant's consent extended to the storage room. Secondly, Ms. Palmer had the authority to consent to a search of the storage room. And lastly, even if you find that Ms. Palmer did not have the authority, Detective Green had an objectively reasonable basis to believe that she did. Here are the critical facts of today's case. Detective Green first spoke with Ms. Palmer, who informed the detective that she was a resident of the property, a maintenance worker, and a friend of the defendant's. Detective Green then spoke with the defendant in front of the mansion. He asked if he could search the estate. She responded, "Feel free to search the house and the garage," and accompanied that consent by waving her arm. Detective Green then found Ms. Palmer in the kitchen. He asked Ms. Palmer if he could search the pool house and the storage room. She consented, but indicated she was not in possession of the key. Detective Green then left the mansion and searched the pool house and the storage room, with neither Ms. Palmer nor the defendant objecting. The prosecution's first argument is that, Your Honor, is that the defendant's scope of consent extended to the storage room. Looking to the Supreme Court case of Florida v. Jimeno, the 10th Circuit case of U.S. v. Pena, and the California Supreme Court case of People v. Harrington, a search is constitutional if an officer has an objectively reasonable basis to believe that the scope of consent extends to a certain area.
Well, let's talk about some of those cases, all right? Let's talk about, what was the first case you decided? Florida versus Jimeno.
Yes, Your Honor.
You know, that case is a car search, right? With a bag inside of it. You know, how is that even remotely similar to this, where you have a larger estate, certainly, but you have a main house, right, that was specified in the consent. You've got a garage that's attached, as far as I can see from the diagram, right? And then across the way, I think it was described by defense as some 35, 40 feet away, you've got a pool in the middle, and then you've got this, pool house and storage shed. I mean, how can you say that it's objectively reasonable for the officer, when the defendant is waving his arms and saying, well, search the house and the garage, to extend that to a building that is so far away from the house, completely detached, right? No other consent is made, and then cite this Florida case for the proposition that makes it okay. For that case, you've got a car, right? And inside the car, you have a paper bag, if I have my facts right.
Yes, Your Honor.
Right? Okay. That's distinguishable, isn't it?
Well, Your Honor, in Florida v. Jimeno, a police officer approached the car and asked the husband sitting in the car if he may search for drugs. The husband consented to a general search, and the court ruled that if the husband did not want the officer to search the paper bag within that car, he needed to specifically say so. In addition, the court established in that instance that if an officer has an objectively reasonable basis to believe that the scope of consent extends to a certain area, then the search of that area is constitutional. And that is the precedent we can apply to today's case. Detective Green had an objectively reasonable basis to believe that the defendant consented to a search of the storage room. We must look to the totality of the circumstances. The defendant gave 2 types of consent, verbal and implied. Verbally, the term house is ambiguous. Detective Green did not know which place of residence on that property it would necessarily refer to, the house or the pool house. In addition, the implied consent was also a general consent to search the entire property.
You really think there's a difference between a house and a storage shed, or a storage room, or a pool room?
Excuse me, Your Honor?
Is there a reasonable distinction to be made, do you think, between a house and, say, the storage area or the pool house?
Well, Your Honor, yes, there's a reasonable distinction between the main house and the pool house, but both are places of residence and could be referred to as a house. Now, in this instance, the storage room is included within the pool house. It is the same unit. Now, Ms. Barkley has argued that there are two separate areas. However, Your Honor, there are merely two rooms in the same unit, and thus, if Detective Green had an objectively reasonable basis to believe that general consent was given, then this would extend to the pool house and consequently the storage room.
Well, that harkens back to the other case that you cited, that U.S. Supreme Court case, right? U.S. versus Pena, right?
That is a 10th Circuit case, Your Honor.
I'm sorry, 10th Circuit case, thank you. I'm elevating them already. Yeah, let's talk about the 10th Circuit case of Pena, 1998 decision, as I recall. That case, you had, a bathroom in an apartment complex or something like that, right?
Yes, Your Honor. It was a hotel room.
Yeah. So that's clearly, within the scope of consent, right? And it'd be reasonable for the officer to search the bathroom, certainly, in a hotel room. But here, let me back up for a minute. If the defendant had said, search my home, period, you'd probably have a stronger argument, would you not?
Yes, Your Honor.
But the defendant didn't say that, did she? The defendant said, search my house and garage.
Yes, Your Honor.
All right. So what else makes it reasonable for this officer to believe that extends to buildings other than the house?
Well, two main things, Your Honor. First, her consent was casual. According to Detective Green, the way she answered was casual. Now, in no way did the defendant specifically state to the detective that he was not allowed to search any area on that property. She did not say, search the house and the garage, but you can't go in the storage room or the pool house. And secondly, Your Honor, her implied consent. Now, standing in front of the mansion, by pointing, according to Ms. Markson's statement, to the house and the garage, she would still be making an arm wave towards the general estate, Your Honor. An objectively reasonable person would have taken this to be a general consent to search the entirety of the property.
All right.
The prosecution's second argument is that Ms. Palmer did not have the authority, that Ms. Palmer did have the authority to consent to a search of the storage room. Looking to the Supreme Court case of U.S. v. Matlock, a search is constitutional if a third party who has joint access and control consents to a search of a common area. Now, in this instance, Ms. Palmer did have authority. As you can see, Your Honor, the storage room is part of her residence. It is in the same accommodation. There is a common wall, Your Honor. In addition, she had access to the room. She entered that room. And lastly, if you look to Ms. Palmer's statement, page 26, lines 14 through 15, it states, sometimes I move stuff from the house into the storage room for Jess. Now, this would be outside the scope of her activities as a maintenance officer. Thus, Your Honor, she does have authority to consent. The prosecution's last argument is that even if you find that Ms. Palmer did not have authority, Detective Green did have an objectively reasonable basis to believe that she did, pursuant to the Supreme Court case of Illinois v. Rodriguez. Detective Green knew that she lived within that pool house, that she had access to the storage room, and that she was a friend of the defendant.
Yes, but it was locked. Didn't have the key, right?
Yes, Your Honor. The interior door was locked, though the exterior door was not in this instance.
Okay, let's assume that there's joint access, or even a hint of joint access, right? Looking at that shed and going into it, that storage room, and seeing a script with the defendant's name on it, that's a personal item, wouldn't you say? I mean, that's not like a gun or a bullet or a bloody sheet or something like that. I mean, it's a personal item, is it not? Would you agree with that?
Well, yes, Your Honor. It is.
Well, if you agree with that, then what about People v. Cruz, right? Where it says even if you have joint access or sharing the premises, police are not authorized to search and seize personal items, right?
Well, in People v. Cruz, Your Honor, there were two temporary guests who were staying at the apartment. The police asked for consent for one guest who gives a general consent. Now, the police officers then searched the belongings of another temporary guest. Now, the court ruled in that instance that the police officer did not have an objectively reasonable basis to believe that the one temporary guest could consent to the items of another temporary guest. Now, this is distinguishable from our case today, as both Ms. Palmer and the defendant are permanent residents on the property, and thus both have joint access and control. In addition, if Ms. Palmer does have joint access and control of the storage room, she would have access to those things. As I mentioned before, Your Honor, at times she moved items from the house into the storage room for Jess, meaning she entered that room to perform other duties than her groundkeeping job, Your Honor. As such, she would have access to those other items. Furthermore, it is the prosecution's position today that the second search argument, in which Mrs. Barkley has stated that Detective Green, by looking through that stack of scripts, violated further her client's rights, is both baseless and irrelevant. If this court finds that consent was given in today's instance, then the scope of consent would extend to every item within that storage room, including the stack of scripts. And if this court finds that consent was not given, then any search after that point would not be admissible. Thus, Your Honor, it is the prosecution's position that you could not consider this argument in today's case.
Thank you. Is there any rebuttal?
Yes, Your Honor. The prosecution has stated many cases in her argument. Let me begin with the case of Harrington. Now, the prosecution has stated that this would be applicable to the case at hand. However, there are a few factual distinctions which make Harrington starkly different than the case at hand. Now, in the case of Harrington, a defendant stepped aside from the doorway and ushered police in, which was found to be a common gesture amounting to come on in. In our case at hand, not only did Miss Markson point at the building she wanted searched, but she also made a verbal statement: "You can search the house and the garage." This could not reasonably be interpreted as a common gesture amounting to "You can search my entire estate." And additionally, Your Honor, in the case of Harrington, it was found that the consent was only consent to enter, not consent to search. Now, in the case of Harrington, when detectives entered, there was marijuana in plain view, and thus a search and seizure could be conducted. In the case at hand, there was no contraband in plain view, and therefore, even if Detective Green felt that Miss Markson's hand gesture extended to the pool house, he would merely have consent to enter the storage room, not consent to conduct a search. The prosecution has also stated the case of Florida v. Jimenez. However, in this case, detectives clearly stated to the husband and wife that they were looking for narcotics. Therefore, a small baggie would reasonably be within that consent, and therefore it was.
Also, you made the comment, as I recall just a moment ago, that the gesture was just to the house and the garage, right?
Yes, Your Honor.
But the evidence shows otherwise, doesn't it? It's more of a general wave. There's no evidence, unless you can point to something that I'm missing, that suggests there was a pointing to the house and the garage. Certainly there was the statement, right? And the attitude and the waving was casual. The response was casual. And I believe the evidence shows that the defendant waved her arm around or something like that, right?
Well, in Miss Markson's statement, directing your attention to page 35, lines 23 to 25, Miss Markson states that she said, "You may search the house and the garage," and she felt that she pointed to each of these buildings. Now, Detective Green, in his statement, felt that the answer was casual and the gesture was vague and ambiguous. Now, even assuming that that gesture was vague and ambiguous, the defense still contends that because it was trumped by the verbal statement, and because the house and garage were the only two buildings visible, that is all that her consent could extend to. May I proceed?
Yes, thank you.
The prosecution has the burden of proof in defending Detective Green's actions. They have not met this burden, and therefore, this search was unconstitutional. The defense once again respectfully requests that the script "murder by monoxide" be excluded from trial. Thank you, Your Honor.
Thank you, counsel. Prosecution, have a rebuttal?
Your Honor, in our case today, we must look to the totality of the circumstances. Whether Detective Green acted reasonably when he investigated the apparent death of Miss Taylor Rodriguez, Your Honor. Now, in this instance, let's look first to the defendant's consent. She did verbally consent to the house in the garage, though this consent was casual. Now, her implied consent was, in essence, Your Honor, vague. Now, according to the defendant, she pointed to each location. But in this instance, we are not concerned to what subjectively she pointed to. We must look instead to what an objectively reasonable person would have inferred from her implied consent. Now, by pointing to two locations, this would be an arm wave, just like according to Detective Green's statement. As such, Your Honor, this was a general consent to search the entirety of the state. Secondly, it is the prosecution's position today that Stoner v. California is distinguishable and that Ms. Palmer did have authority to consent to a search of the storage room. In Stoner v. California, the court has ruled that the clerk did not have authority and that officers did not have an objectively reasonable basis to believe that the clerk did have authority. But this is different from our case today. In our instance today, Ms. Palmer and Ms. Markson were both residents. Ms. Palmer lived in the same unit as the storage room. Thus, Your Honor, Stoner is not applicable. Thus, the prosecution respectfully requests that you deny the defense's motion. Thank you.
Matter submitted on both sides then? Yes?
Yes. Yes, Your Honor.
Thank you very much. Court, having read the pleadings in this case, considered the arguments of both counsel. Court's ruling is that the motion to suppress is denied. All right, let's proceed. Opening statement by the prosecution, please.
Your Honor, before we proceed with the opening statements, the prosecution has a few preliminary matters to address.
All right.
First, Your Honor, the prosecution would ask that the record reflect that the diagrams have been marked for identification purposes only. There's Diagram A, a map of the Markson mansion. Diagram B, a copy of the script that Detective Green found at that same residence. Diagram C, a depiction of the sword and scabbard that Detective Green also found. And finally, Diagram D, a diagram showing the wounds to the victim's head. This is for identification purposes only, and these have been shown to the defense counsel before the start of today's proceedings.
Is that true?
Yes, Your Honor.
Thank you. Appreciate that remark, counsel, and we'll keep all those exhibits in mind, won't we? All right. Thank you very much. At this time, I am calling once again case of People versus Markson. Ms. Markson has been charged with first-degree murder in violation of California Penal Code sections 187 and 189. Does the district attorney have an opening statement to make?
Don't underestimate me. You have no idea the power I have. You can't leave me. You're mine. If you leave me, I'll kill you. These are the words of the defendant, Jess Markson. Taylor Rodriguez tried to leave, and Miss Markson delivered on her promise to kill her husband. The evidence will show the following. Jess Markson cast Taylor Rodriguez on the lead role of her hit TV show, Newport Beach. Soon, they fell in love and got married. But it wasn't long that Mr. Rodriguez got restless and decided to leave not only Newport Beach, but Miss Markson as well. Today, Alex Palmer, a close friend of the defendant, will take the stand and tell you of Miss Markson's increasingly jealous behavior and violent remarks. Brook Martini, a defense witness, will also take the stand and describe her utter bewilderment at why Mr. Rodriguez would stay with someone as ruthless as the defendant. Toby Keaton will also discuss his concern for Mr. Rodriguez's safety and how on the night of October 12th, Mr. Rodriguez told Toby Keaton that he was going to go home, pack up his things, and leave Miss Markson the next day. The day he was instead found dead, Your Honor. Today, Dr. Expert Francis Stone will also take the stand and explain how all of the facts in today's case are consistent with murder. She will discuss with you the bruise found on the deceased's forehead and how the shape and coloration of this bruise was consistent with the scabbard Detective Green found in the defendant's home. Your Honor, at the end of today's trial, the people urge the court to recall the words of the defendant. The defendant told Taylor Rodriguez not to underestimate her. and today the court must do the same. Do not underestimate the defendant's fiery temper. Do not underestimate the defendant's jealousy. Do not underestimate Jess Markson. Thank you.
Thank you, counsel. Does the defense have an opening statement to make, or do you wish to reserve or waive it?
The defense wishes to proceed at this time, Your Honor.
Very well, thank you.
Once again, my name is Patrick McKenzie, and I have the honor of presenting the opening statement on behalf of Jess Markson. May I proceed?
Yes, please, counsel.
Everything in my life has gotten so difficult lately. Sometimes I think it might be better if I just gave it all up. Life is just so hopeless. Why go through so much pain? I am not sure that life is worth living like this. Your Honor, these were the words of Taylor Rodriguez. And today the evidence will show that Mr. Rodriguez had a long-standing battle with depression, and that this depression of his culminated on the morning of October 13th and ended in Mr. Rodriguez taking his own life. The facts will show that Jess Markson did not commit any crime. Now, Mr. Rodriguez had struggled with this depression of his for years. He let this depression take over his life. 2 years ago in Denver, Mr. Rodriguez attempted suicide. Hoping that a change of scenery would help his depression, he moved to Los Angeles to pursue an acting career. But it was a difficult transition for him, and his depression got worse and worse. Even after he landed a starring role on a hit TV show and was involved in a loving marriage, nothing could bring him the happiness he desired. No matter how many positive aspects there were to his life, nothing could make him happy. And even being a star did not bring him happiness. Now, on the morning of October 13th, Mr. Rodriguez arrived home drunk from a party with a blood alcohol content of 0.15%. Today, Dr. Pat Choy will testify that alcohol is a depressant, and depressed individuals are much more likely to commit suicide while under its influence. Now today, Dr. Stevie, Rico, and Brook Martini will testify that they heard on multiple occasions Mr. Rodriguez talk about taking his own life. Now, Mr. Rodriguez at that party saw Brook Martini, his love interest, and the only person who made his life worth living, on a date with another man. And this was a party in which Mr. Rodriguez left because he was so upset and emotionally distressed. The next morning, Mr. Rodriguez was found dead in his Aston Martin. The key was still in the ignition. The cause of death was carbon monoxide poisoning. Today, the evidence will show that Mr. Rodriguez was not only a victim of depression, but ultimately of suicide. Your Honor, this tragedy may have taken place in Hollywood, but it is a real-life tragedy. Do not let Miss Saeed's Hollywood work of fiction take the place of reality. The evidence will show that on the morning of October 13th, Taylor Rodriguez committed suicide while Jess Markson lay asleep in her bed, as innocent as she is before you today. Thank you, Your Honor.
Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
Yes, I do.
State your name for the court, spelling your last.
Alex Palmer, Palmer.
May I proceed, Your Honor?
Yes.
Good morning, Ms. Palmer.
Good morning.
I'd like to begin by directing your attention to the evening of October 12th. What were you doing that night?
Well, that night was our pool night. Jess Markson had invited me over to her mansion to play pool and drink some beer.
How do you know Jess Markson?
Oh, I've known Jess for a long time. We're good friends. About 15 years ago, I worked with her in show business, and then after I got out of jail and couldn't find a job, Jess employed me as her live-in gardener, so I even live on her estate.
Looking back to that night of October 12th, what, if anything, do you recall of Miss Markson's behavior?
Oh,
Well, that night, Jess did seem pretty angry. I remember she was drinking, and she kept swearing and saying these awful things about Taylor.
What, if anything, do you recall of these awful things?
Well, I remember Jess said that Taylor was ungrateful, and she also said that Taylor was going to get what was coming to someone who betrayed her.
Miss Palmer, did you ever leave the defendant's presence that night?
At around midnight, I went back to the pool house to watch some TV.
Did you ever stop watching TV?
At 1:15, yes.
Why did you stop?
Well, I heard some yelling coming from the mansion.
What did you observe, Miss Palmer?
Let's see, I remember it was pretty windy that night, and, well, while I couldn't hear everything that was said, I do believe I heard Jess and Taylor arguing.
Miss Palmer, you said that you had the TV on. How could you hear what was going on?
Oh, well, I put the TV on mute, and the window was open.
How far away were you from the Markson mansion?
See, from the pool house to the mansion, I'd say that's about 35 feet.
To your knowledge, did the argument ever end?
Actually, it ended quickly.
I'd like to direct your attention to a different area, Miss Palmer. Have you ever heard the defendant threaten Taylor Rodriguez?
Actually, just a couple days before Taylor died, I do remember Jess threatening to kill him.
Would you please describe this incident for the court?
Well, I remember Jess just yelling at Taylor, "You think you'd be happy with Brook? I'd kill you both before I let that happen. You have no idea the power I have. Don't underestimate me."
Miss Palmer, had you ever heard the defendant speak of killing before this?
Well, there was that time back in July when Jess asked me how much it would cost to have someone killed, like by a hitman.
Finally, Miss Palmer, would you describe the circumstances in which you last saw Taylor Rodriguez?
The last time I saw Taylor was around 12:30 on October 13th. I was just going into the garage to get a hose, and I found Taylor just slumped over in the Aston Martin, and he was dead.
Thank you, Miss Palmer. Your Honor, no further questions at this time.
Thank you, counsel. Cross-examination?
Yes, Your Honor. Permission to approach the exhibits during this cross-examination?
Yes, granted.
Miss Palmer, you've been convicted of assault, correct?
That's correct.
Now, you testified on direct examination that you had a conversation with Miss Markson when she asked you about the price of hitmen, correct?
That's right.
Miss Markson did not ask you if you knew a hitman, did she?
No, she didn't.
Miss Markson did not ask you for you to get a hitman for her, did she?
That's correct, she didn't.
Miss Markson only asked the price that a hitman might cost, isn't that true?
That's what she asked.
She told you not to go through too much trouble for her in finding this out, didn't she?
Oh, she said that as well, yes.
You never got back to Miss Markson with an answer, did you?
No, I didn't.
And she never brought it up again, did she?
That's correct.
Now, Miss Palmer, you're a tenant on Miss Markson's mansion, correct?
Yes, I am.
Miss Markson's a well-known producer, isn't she?
I believe she is.
You've spent time in jail, haven't you?
Yes, I have.
You found the body, didn't you?
That's correct.
You knew the police were coming, didn't you?
Yes, I did.
And then the police interviewed you, correct?
Yes, I was interviewed.
And it was at that point that you told the police that you heard a fight the night before, correct?
Yes, I said that.
Now, Miss Palmer, you were in your pool house watching television when you heard these noises, correct?
Yes, I was.
And you can see that your pool house is 35 feet away from Miss Markson and Miss Rodriguez's house, correct?
That's correct.
You only have one window facing the house, isn't that true?
Yes, that's also correct.
Miss Palmer, it was a windy night, wasn't it?
Oh, it was windy, yes.
It was so windy that night, you couldn't hear what was being said, could you?
Not exactly, no.
You had consumed alcohol shortly before hearing these voices, hadn't you?
That's right.
You didn't see any lights on in the mansion, did you?
There were no lights that I could see, no.
You did not see anyone in the mansion, did you?
No, I didn't.
You could not distinguish exactly who the voices belonged to, could you?
Not exactly, no.
And you don't know what was said, do you?
That's correct, I don't.
Now, it's safe to say that you would not want either Miss Markson or Miss Rodriguez hurt, correct?
Oh, I wouldn't want them hurt, no.
So if on the morning of October 13th, you thought anything violent was occurring in that house, you would have tried to stop it, wouldn't you?
Objection, creating a material fact.
Your Honor, Miss Palmer has stated that she did not do anything in response to these voices and did not leave her pool house. Therefore, to ask her about that circumstance does not create a material fact, and she does have that personal knowledge.
Your Honor, it is the prosecution's position that it does create a material fact and that it aids the defense more than the prosecution. Moreover, it is not included within this witness's witness statement.
Thank you. Objection is overruled. Proceed.
Ms. Palmer, if on the morning of October 13th you thought anything violent was occurring in that house, you would have tried to stop it, wouldn't you?
Objection relevance?
Your Honor, this has a tendency in reason to show that Ms. Palmer did not think anything violent was occurring in that house, and that because she knew both Ms. Markson and Ms. Rodriguez well, shows that nothing violent was occurring in that household.
May I be heard, Your Honor? Your Honor, it is the prosecution's position that what this witness thinks or feels is not relevant, just the facts. What her observations are as a lay witness are relevant, Your Honor.
I'll overrule objection, but let's watch the speculation. Go ahead.
Yes, Your Honor.
I suppose I probably would have tried to do something.
And when you told Jess about her husband's death, she looked shocked, didn't she?
Yes, she did.
Thank you, Ms. Palmer. Your Honor, I have no further questions at this time.
Anything on redirect?
Briefly, Your Honor.
All right, thank you.
Ms. Palmer, on the early hours of October 13th, what did the voices sound like coming from the Markson mansion?
There was yelling, and they sounded angry.
Thank you, Ms. Palmer. Your Honor, no further questions. May this witness be excused?
Yes, is there any recross or no?
No, Your Honor.
Thank you. You may step down. You're excused.
Good morning, Mr. Keaton.
Good morning.
Are you currently employed?
Oh, yes, certainly.
What do you do for a living?
Well, I'm an actor, actually, on Newport Beach.
Who are some of the people that you've worked with on Newport Beach?
Jess Markson was the producer of the show. I was particularly close with Taylor Rodriguez.
Well, what was working with Miss Markson like on the set of Newport Beach?
Jess does a lot of yelling on the sets.
Objection, Your Honor. Improper character evidence.
May I be heard, Your Honor?
Yes.
Your Honor, this is proper character evidence as it goes to demonstrate why the defendant is guilty of a specific aspect of that first-degree murder charge. Now, in order for any character evidence to be relevant, it must go to a specific aspect of that charge. And this tendency to yell, this tendency for having a very fiery temper, which this witness will go on to testify, demonstrates that the defendant could have had not only the malice of forethought to commit this crime, but also the willful and deliberate aspect, Your Honor.
Your Honor, may I be heard?
Yes, go ahead, counsel.
Your Honor, regardless of what this is going to prove, it is still improper character evidence. Under the mock trial simplified rules of evidence, there is no exception or distinction to the character rule, and therefore this is inadmissible.
May I be heard, Your Honor?
Yes.
If Mr. Goodstein is referring to the fact that the defense has not made character an issue, the prosecution would argue that since there is no recalling of witnesses according to the mock trial rules of evidence, the prosecution has both the right and the obligation to bring up other character evidence of the defendant at this point in the trial to rebut any character evidence of the defendant that the defense will make an issue later.
Objections overruled. Thank you. Proceed.
Yes, Your Honor.
Were you finished with your answer, Mr. Keaton?
No, I was going to say that Jess really does appear to have a very fiery temper.
Well, you also mentioned somebody by the name of Taylor Rodriguez. Did you ever see him interact with the defendant?
Well, they were married, so of course.
During the time that you knew them, did you ever observe their relationship seem to change?
I would say there were a number of things that I observed, really, two specifically in the last few months leading up to October.
Let's talk about each of those separately. What was the first incident?
Oh, this was Taylor had actually just announced that he was going to be leaving Newport Beach. And I remember, Jess just seemed really furious about the whole situation. She actually snapped at me once.
Mr. Keaton, you said that there were two things that you observed. What was the second of these?
And this would have been about the time Taylor was talking with me about the possibility of actually getting back together with his ex, Brook Martini.
How, if in any way, did the defendant respond to that?
Oh, I remember a number of outbursts from Jess. Like last September, actually. They got in a big fight.
Could you please describe that fight for the court?
Oh, well, I was just talking with Taylor, and And Jess bursts into the room and just starts yelling, "Oh, I can't believe you'd want to get back together with Brook. You know, you're mine. You can't leave me." She actually grabbed a vase, threw it against the wall.
I'd like to talk to you about the evening of October 12th, 2005. Did you see any similar fighting on that evening?
I did.
Could you please describe that fighting?
Well, I had just gone to the Markson mansion to pick up Taylor for a party that evening. And as soon as I showed up, Jess just starts going off again. "Oh, you can't go to that party tonight and see Brook. You're mine." She actually said to Taylor, "If you leave me, I'll kill you."
Mr. Keaton, did Mr. Rodriguez leave the defendant on that evening?
Yeah, we did go to Brook's party.
Did you leave Brook's party together that night?
We did.
Well, what, if any, conversation did you have with Mr. Rodriguez on the way home?
Oh, I remember I told Jess I did not think he should be going back to that house. Not back to Jess.
How, if in any way, did Mr. Rodriguez respond?
Oh, he said he was going to go back. He was going to pack his things, and he was going to leave Jess the next day.
Thank you, Mr. Keaton. Nothing further at this time, Your Honor.
Cross-exam, Mr. Goodstein.
Yes, Your Honor. Mr. Keaton, it appeared to you that Mr. Rodriguez had a difficult transition into stardom. Isn't that true?
Oh, yes, he certainly did.
And it appears to you that Mr. Rodriguez often felt alone and isolated. Isn't that true?
That's what it seemed to me.
Mr. Keaton, you had the opportunity to observe Mr. Rodriguez and Miss Martini together, correct?
I did.
Now, based on your observations, you concluded that it was inevitable that they would get back together. Isn't that true?
That's what I believed.
You observed Mr. Rodriguez to always be happy after getting off the phone with Miss Martini, correct?
He did appear to be, yes.
Now, on the night of October 12th, you and Mr. Rodriguez went to Brook Martini's party, correct?
We did.
When you got there, you saw Brook Martini with a date. Isn't that true?
She did seem to be, yes.
After you arrived, Mr. Rodriguez began to drink heavily. Isn't that true?
He did.
In fact, you observed Mr. Rodriguez to not having any fun at the party. Isn't that true?
From what it seemed to me, yes.
In fact, you left the party that night because Mr. Rodriguez was so visibly distressed. Isn't that true?
That is correct.
Mr. Keaton, after Mr. Rodriguez got out of your car that night, you don't know what he did, do you?
I did not see it, no.
And isn't it true that you felt guilty that you did not bring Mr. Rodriguez home with you that night?
Oh, I did feel guilty.
Thank you, Mr. Keaton. Your Honor, I have no further questions.
Thank you, counsel. Any redirect?
Briefly, Your Honor. Mr. Goodstein just asked you about whether or not you knew what Mr. Rodriguez did once he got inside that house. Now, although you didn't see him, did he tell you anything about what he was planning on doing?
Objection, Your Honor. Asked and answered. This has already been explored on direct examination.
May I be heard, Your Honor?
Yes.
Your Honor, while it has been explored on direct examination, the point of redirect examination is to rebut issues made during cross-examination. This is merely to rebut Mr. Goodstein's cross of this witness.
Thank you. Objection's overruled. Thank you.
Yes, Your Honor.
Proceed.
Taylor was very clear that he was going to pack and get ready to leave Jess.
Thank you, Mr. Keaton. May this witness be excused, Your Honor?
Yes. Mr. Keaton, thank you. You're excused. Next witness, please.
Good morning, Detective Green.
Good morning.
Where exactly are you a detective?
Well, I've been a detective at the Hollywood Police Department for the last 11 years, but I've been working there for the last 20.
Well, do you recall if you were doing detective work at about 12:30 on the afternoon of October 13th, 2005?
Well, that's when I arrived at the garage of the Markson residence. Yes, I was.
Could you please describe your initial observations of the scene for the court?
I saw one Taylor Rodriguez dead in the driver's seat of an Aston Martin, and I noticed that the keys were in the ignition of the vehicle.
What, if anything, did the keys being in the ignition indicate to you?
This indicated a possible suicide.
What, if any, observations did you make of Mr. Rodriguez's body?
Well, I noticed, among other things, that Mr. Rodriguez had a large bruise on his forehead, which would indicate a blow to the head.
Well, did you speak to anybody after observing the body?
Well, I spoke with a number of people, including Miss Alex Palmer, Miss Jess Markson, Mr. Toby Keaton, Miss Brook Martini, and Miss Stevie Rico.
Well, you mentioned that you spoke with Jess Markson. Do you see her in the courtroom today?
I do.
Could you please identify Miss Markson by where she's seated and what she's wearing?
Miss Markson is seated at the end of the table to my right in the white top.
Your Honor, will the record reflect that Detective Green has identified Jess Markson?
Yes, the record will so reflect. Thank you.
Detective, what, if anything, unusual did you notice about the defendant's appearance while you were speaking to her?
Well, I noticed that Miss Markson had a rather swollen lip.
Were you ever able to perform a search of the residence?
Yes, ma'am, I was.
What, if anything, did you take note of on that search?
Well, I took note of a large scabbard that I found in the living room, and I also took note of a script that I found in a storage room out by the pool house.
With the court's permission, would you please approach diagram B with the red pen?
Yes.
Detective, I'd like to have you take a look at that diagram. What does it appear to be?
This appears to be a copy of the script that I found.
Would you say that it's a fair and accurate copy of that script as of October 13th, 2005?
Yes, I would say it is.
In that case, with the red pen, could you please circle the writing in the lower right-hand corner?
Of course.
Also with that red pen, could you please place your initials and badge number in the lower left-hand corner?
Certainly.
Your Honor, will the record reflect that the detective has circled the writing in the lower right-hand corner and placed his initials and badge number in the lower left-hand corner, all with the red pen?
Yes, indeed. It shall reflect. Go ahead.
In that case, Your Honor, the people move diagram B into evidence?
Any objection?
No, Your Honor.
All right. It'll be admitted in evidence. Exhibit B.
Detective, could you please describe the contents of that script?
Of course. The script is titled Murder by Monoxide, and it's about a husband who kills his famous wife, and he kills her by subjecting her to carbon monoxide poisoning. He kills her in this manner in an attempt to make it look like a suicide.
Objection, Your Honor. The answer contained hearsay.
May I be heard, Your Honor?
Yes.
Your Honor, there are a number of reasons why this is admissible evidence. First, Your Honor, the detective is testifying to information from an exhibit. That alone makes it admissible. However, if the court would like another hearsay exception, a hearsay exclusion, this is not being offered for the truth of the matter asserted. This is merely going to the effect on the listener. The listener in this situation being the defendant. Now, it's the prosecution's position that after reading this script, the defendant got in her mind the idea and the manner in which she could kill her husband. So not only is this not hearsay, but even if you do consider it hearsay, it is allowable since it's part of an exhibit.
May I be heard, Your Honor?
Yes.
If it's not offered for the truth, then may it be admitted for that limited purpose only.
Granted. Move on.
During the search that you conducted, were you ever able to see Mr. Rodriguez's room?
I was.
What, if anything, did you find there?
Well, it was actually what I didn't find that was more interesting.
What do you mean?
Well, as I said before, I had spoken with Mr. Toby Keaton, and he informed me that Mr. Rodriguez was to go inside and pack when dropped off at 1:15 the previous evening. When I searched Mr. Rodriguez's room, nothing appeared to be out of place at all. No signs of packing.
Thank you, Detective. Nothing further at this time.
Thank you. A cross-examination, please.
Yes, Your Honor. Detective Green, the script that you found was in the middle of a stack of scripts, wasn't it?
That's correct, counsel.
It was underneath many scripts, wasn't it?
Yes.
You had to individually search through multiple scripts in order to find it, didn't you?
Yes, ma'am.
Jess Markson is not the author of the script, is she?
No, she's not.
The script is 5 years old, isn't it?
According to the date on the script, that is correct, ma'am.
You spoke with Alex Palmer at the scene, correct?
I did speak with Miss Palmer.
She volunteered various information to you, didn't she?
Yes, she did.
She changed your investigation, didn't she?
I would say so.
Objection relevance?
Yes.
Your Honor, this has a tendency and reason to prove that Alex Palmer was rash in her testimony, and Detective Green relied on Alex Palmer's testimony, though he did not know all of the circumstances about her.
May I be heard, Your Honor?
Yes.
Your Honor, if Ms. Young is attempting to offer Alex Palmer as a third-party culpability suspect, the prosecution would argue that in order for the defense to use this theory, they must be able to demonstrate that Alex Palmer had something beyond means, motive, and opportunity to commit this crime, something beyond circumstantial evidence. Now, it's the prosecution's position that the defense has not, will not, and cannot be able to offer such evidence.
May I be heard, Your Honor?
Yes.
The defense is not saying Alex Palmer is a culprit. However, we are saying that testing this witness's credibility by challenging his investigation.
Yes. Objections overruled. Thank you.
Yes, Your Honor.
Proceed, Counselor.
She changed her investigation, didn't she?
I would say she did.
It was only after speaking with Miss Palmer that you believed it was a possible homicide, correct?
That is correct.
You also spoke with Jess Markson at the scene, didn't you?
I did speak with the defendant, yes.
She allowed you to search her house, didn't she?
Yes, she did.
She was cooperative, wasn't she?
I would say she was.
She gave you a reason for her swollen lip, didn't she?
Objection, hearsay.
Your Honor, no out-of-court statement has been offered.
May I be heard, Your Honor?
Yes.
Although Ms. Young did not specifically state Jess Markson told you this, by saying that she gave you a reason for the swollen lip, this is relying on a hearsay statement and is thus still hearsay.
Overruled. Go ahead.
She gave you a reason for her swollen lip, didn't she?
Yes, she did.
Now, you seized the scabbard found at the scene, correct?
Sword and scabbard, that's correct.
It was hanging on a mantle, wasn't it?
Above a fireplace, yes, that's correct.
It wasn't hidden, was it?
No, it was not.
You didn't find any signs of a struggle in Taylor's room, did you?
Nothing was out of place at all, actually, so no.
When you entered the garage, you saw the decedent in the driver's seat of the Aston Martin, didn't you?
Yes, that's correct.
His head was tilted to the left, wasn't it?
That's also correct.
The key was in the ignition, wasn't it?
I did take note of that.
Based on 20 years of experience, your first conclusion was that it was a suicide, wasn't it?
Those were my initial observations, yes.
Thank you, Detective Green. No further questions, Your Honor.
Good morning.
Why are you here today?
Well, I was called here today to discuss my conclusions regarding the manner of death of the victim, in this case, Mr. Taylor Rodriguez.
Would you please describe your professional background for the court?
Certainly. I received my medical degree from Stanford University. I've been practicing forensic science for about the past 15 years now. I recently attended a 2-week seminar on the nature of bruises and burns, and I presently work as a lab manager for the state.
Dr. Stone, what were your conclusions in today's case?
I concluded to a reasonable degree of medical certainty the victim sustained a bruise to the center forehead, most likely rendering him unconscious. He was then placed in his vehicle with the ignition turned on and died about 20 minutes later to carbon monoxide poisoning between the hours of 1:45 and 2:15 a.m. All this was included in my report and given to the defense.
Dr. Stone, I'd like to direct your attention to Dr. Choy's conclusions about the overall circumstances in which Mr. Rodriguez died. Were you familiar with them?
I believe that Dr. Choy concluded that the victim suffered from depression and committed suicide.
And do you agree with this conclusion?
Objection, Your Honor. This witness is not qualified in psychology.
May I be heard, Your Honor?
Yes.
Your Honor, first of all, it is the prosecution's position that this is an issue of weight and not admissibility, as it has already been stipulated, Your Honor, that Dr. Francis Stone is a qualified expert witness. Now, on top of that, Dr. Stone just testified that she put all of her conclusions and qualifications into a report that she handed to the defense. The defense saw her conclusions about a suicide, saw her qualifications with a medical degree, Your Honor, and then stipulated that she was a qualified expert witness. The fact that they saw her conclusions about a suicide and then stipulated that she was a qualified expert witness makes her testimony admissible, Your Honor.
May I be heard?
Yes, counsel.
This witness is an expert in forensics, but she has no degree in psychology and is therefore not an expert in psychology.
I agree that it goes to the weight of the evidence, not its admissibility, so I'm going to overrule the objection. Thank you,
Yes,
counsel.
Your Honor.
Proceed.
Yes, Your Honor. Would you like me to repeat the question?
That's all right. I observed several behaviors in the deceased that would directly contradict Dr. Choy's conclusions. Therefore, I respectfully disagree.
What were these behaviors that you observed?
Well, Mr. Rodriguez had a career that was taking off. In addition, and more importantly, he had made plans to leave his spouse on that evening. Now, making plans is not indicative of suicidal behavior. People will not generally say things that they will not be around to do when contemplating suicide. Therefore, I do not believe that suicide is a reasonable explanation for the manner of death.
Dr. Stone, with the court's permission, would you please approach diagrams C and D? Do you recognize diagram D?
This appears to be the diagram that I made of the bruise found on the victim's body.
Is it a fair and accurate representation objection to diagram C with this be an example of that scabbard?
This would be an accurate depiction of that scabbard given to me by Detective Green.
Dr. Stone, with the court's permission, would you please resume your seat? Your Honor, at this time, the people move to enter diagrams C and D into evidence.
Yes, any objection?
No objections, Your Honor, as long as the defense is permitted to mark on them.
No objection, Your Honor.
Thank you for that stipulation. Appreciate that. Exhibits C and
D, Your Honor.
D, is it? Yes, those will be marked as evidence. Thank you.
Dr. Stone, one final area.
One.
The time of death. How did you arrive at the time between 1:45 and 2:15 a.m.?
I used two methods. First, I took the temperature of the body at the scene, which placed the time of death about 12 hours earlier, 2 o'clock a.m. Back at the lab, I also measured the potassium accumulation in the vitreous humor, which is a transparent jelly of the eye. The amount of potassium that I recorded confirmed that time of death.
Thank you, Dr. Stone. Your Honor, no further questions at this time.
Cross-examine.
Yes, Your Honor. Dr. Stone, on direct examination, you testified that you used the temperature method in your attempt to determine Taylor Rodriguez's time of death, correct?
Yes, that's right.
Many outside factors can affect the accuracy of this method, can't they?
Well, one factor, yes.
Let's go into that one factor. That's the ambient temperature that surrounds the body, isn't it?
Yes.
You relied upon the exterior temperature in Los Angeles, didn't you?
That's correct.
By using the exterior temperature in Los Angeles, you assumed that it was the same as the interior temperature of the garage, didn't you?
Not necessarily, no.
But you didn't measure the temperature in the garage, did you?
No, I did not.
So the only temperature you relied on for the ambient temperature was the temperature in Los Angeles, wasn't it?
63 degrees, that's correct.
And you assumed the temperature in Los Angeles was 63 degrees from 2 a.m. to 2 p.m., didn't you?
It was constant, yes.
Also important in your temperature analysis is the rate at which a body cools, isn't it?
Yes.
By the way, Dr. Stone, an old car that burns fuel inefficiently, running in a small garage for an extended period of time, would raise the ambient temperature of that room, wouldn't it?
It very well might.
And if the ambient temperature is hotter, a body will cool more slowly, won't it?
Yes, it will.
You assumed Taylor Rodriguez's rate of heat loss was 1.5 degrees Fahrenheit, didn't you?
That was my observation, yes.
Any change in this rate of heat loss would alter your temperature, your analysis, wouldn't it?
Yes, it might.
Dr. Stone, each individual bruises differently, don't they?
Yes, that's correct.
Some people bruise more easily than others, don't they?
That can happen, yes.
Assuming the bruise was, in fact, caused by an individual, it could very well have been caused by a right-handed individual, couldn't it?
That is possible, yes.
There were no fingerprints found on the scabbard, were there?
There were none.
It is your contention that the blow that caused the bruise would have had to have been very forceful, isn't it?
Yes.
You do not believe the pool cues could have withstood this impact, do you?
That's correct.
The scabbard was made of wood, wasn't it?
Yes, it was.
There was no damage to the scabbard, was there?
None that I could see, no.
The steering wheel is made of smooth stainless steel, isn't it?
As I recall, that's correct.
When Taylor Rodriguez died, his blood alcohol content was 0.15, wasn't it?
Yes, it was.
This means that on the morning of October 13th, Taylor Rodriguez was highly intoxicated, doesn't it?
Yes.
One last question, Dr. Stone. Taylor Rodriguez died from carbon monoxide poisoning, didn't he?
Yes, he did.
Thank you, Dr. Stone. No further questions, Your Honor.
Thank you. Is there any redirect?
Dr. Stone, Ms. Young mentioned that the bruise
30.
could have been caused by a right-handed person. What is the likelihood of that?
Well, that is certainly less likely, as the angle of the bruise and the positioning of the bruise makes it much more likely that it was in fact inflicted by a left-handed individual.
And also, Dr. Stone, Ms. Young mentioned assumptions. Did anything that Ms. Young said change your opinion in today's case?
Well, since she introduced no facts or reasonable conclusions that I can reconsider, she did not change my ultimate conclusion in this case.
Time.
Thank you, Dr. Stone. Your Honor, no further questions. May this witness be excused?
Yes, thank you, Doctor. Excused.
Good afternoon, Dr. Choy.
Good afternoon.
What is your professional background?
I've been a forensic scientist for approximately 15 years now. I have a PhD in psychology and a certification in advanced forensics.
I'm the lead technician at Southern California Forensic Solutions, an independent forensics firm.
What information did you review in this case?
I reviewed Dr. Stone's autopsy report, interviewed several witnesses, and studied accounts of the deceased's behavior.
What conclusions have you reached as to the cause of Taylor Rodriguez's death?
I've concluded that the death is consistent with a suicide by carbon monoxide poisoning.
Do you agree with Dr. Stone's methods for determining the time of death?
No.
What do you disagree with?
Dr. Stone's methods are affected by several scientific uncertainties. Furthermore, she failed to take the contents of the deceased's digestive system into account. My analysis of Taylor Rodriguez's digestive system leads me to conclude that he died at around 3 a.m. at the earliest.
Besides your time of death discrepancies, you mentioned several scientific uncertainties in Dr. Stone's methods. Could you please describe one of these?
Certainly. One of them involves Dr. Stone's analysis of Taylor Rodriguez's vitreous fluid. There are circumstances in which the vitreous fluid contains potassium before death. If Taylor Rodriguez's vitreous fluid contained potassium before he died, Dr. Stone's conclusions would be very misleading.
What led you to believe this case was a suicide?
I interviewed several witnesses familiar with Mr. Rodriguez, who informed me that he not only exhibited increasing signs of depression, but also made several statements to the effect of life is not worth living. Such behavior and statements are consistent with a suicidal individual.
Were there any incidents in the deceased's life that you took into account?
Yes. Often suicides follow something known as a precipitating event, a dramatic experience in the life of a suicidal individual. In Taylor Rodriguez's life, these would have been his fight with his spouse, his changed career, or the loss of a possible love interest. Any of these events, let alone all of them combined, could lead a depressed person to attempt suicide.
Were there any incidents from the deceased's life in Colorado that you took into account?
Yes. Approximately 2 years ago in Denver, Taylor Rodriguez attempted suicide.
Objection, creating a material fact.
Your Honor, this witness is an expert and may rely upon evidence made known to her outside of the courtroom. She interviewed Brook Martini in this case, and as an offer of proof, will testify that Taylor Rodriguez attempted suicide.
May I be heard, Your Honor?
Yes.
Your Honor, the people agree. Dr. Choy did interview Brook Martini, and that is included within her record. However, within her record, it does not include what was contained within that interview, Your Honor. Directing court and counsel's attention to page 33, line 6. I interviewed several witnesses familiar with Taylor, including Jess, Brook, and Stevie. However, it does not say what that interview contained, and thus Dr. Choy does not have knowledge of that suicide attempt.
Yes. Objections overruled. Proceed.
Why is the fact that Taylor attempted suicide important?
Of all people who commit suicide, nearly 50% have attempted to do so in the past.
Does alcohol have any effects on a person emotionally?
Yes. Many surveys have proven that alcohol leads to depression, and depressed individuals are more likely to attempt suicide while under its influence.
Your Honor, at this time, may the witness please approach the diagram.
Yes, please, go ahead.
Dr. Choy, could you please describe Exhibit B for the court?
Yes. It's a depiction of the bruise found on the deceased's forehead. However, it's slightly misleading because at the scene, the deceased was found with his head tilted to the left.
Why is that important?
Because the deceased's head was tilted to the left. The angle of its impact with the steering wheel and the angle of the bruise are consistent.
Could you please illustrate this using the diagram?
Certainly. As you can see, I've drawn a circle representing the steering wheel, which could have easily caused the bruise on the deceased's forehead.
Thank you, Dr. Choy.
Good morning, Dr. Choy.
Good morning.
Now, Dr. Stone concluded that it was most likely that the bruise was caused by a rod-like instrument. Isn't that correct?
That is correct.
More specifically, the scabbard. True? Is that a yes?
Yes.
Now, the scabbard is straight. Isn't that right?
Yes.
And the tramline bruise is also straight. True?
Objection, Your Honor. Counsel is creating a material fact beyond the scope of the record. Nowhere in the record does it say the shape of the bruise, only the dimensions.
May I be heard, Your Honor?
Yes.
Directing court and counsel's attention to page 11 of the mock trial rules, subsection 11, it says the witness's record includes her own statement, stipulations, and exhibits. Thus, Your Honor, the tramline bruise is straight on diagram Exhibit D, and thus this witness would have knowledge of it.
So ruled.
Yes, Your Honor.
That tramline bruise is straight, Dr. Choy, true?
It appears so.
That steering wheel that you drew, it's curved, isn't that right?
That is correct.
The steering wheel in the Aston Martin was also curved, right?
Yes.
But the court's finished it, you may resume your seat. Directing your attention to the time of death, you stated that at the earliest, Taylor Rodriguez would have had to have died at 3 a.m., true?
Approximately, yes.
And this was based off of the stomach contents, isn't that right?
That is correct.
Dr. Stone, however, arrived at an earlier time, isn't that true?
That is also correct.
Based off of examination of the potassium accumulation in the eye, true?
The vitreous fluid, yes.
Now, Dr. Stone used newer technology in comparison to yourself, isn't that right?
Relatively, yes.
Dr. Choy, one final area. You stated that Taylor Rodriguez had a blood alcohol content of 0.15%, true?
At the time of death, yes.
This is an intoxicated state, true?
Highly intoxicated, yes.
A person that consumes alcohol is more likely to be involved in risky behavior, true?
High amounts of alcohol, yes.
Hypothetically speaking, Dr. Choy, if Jess Markson had consumed large amounts of alcohol, would she be more likely to be involved in risky behavior?
Very large amounts of alcohol? Then perhaps, yes.
Hypothetically speaking, Dr. Choy, would you consider committing murder risky behavior?
Not in this usage of the term, no.
Thank you, Dr. Choy. Your Honor, no further questions.
Anything on redirect?
Yes, Your Honor. Dr. Choy, why in this case wouldn't you consider murder risky behavior?
The term risky behavior as it applies to this case applies only to the theory of suicide, not murder.
Dr. Choy, why do you believe that the steering wheel caused the bruise on Taylor Rodriguez's forehead?
I believe it's most likely that the steering wheel caused the bruise on Taylor Rodriguez's forehead because of the circumstances of his death. It is most likely that Taylor Rodriguez suffered from convulsions while he was dying of carbon monoxide poisoning, and in the process hit his head against the steering wheel.
You heard Dr. Stone testify as to other objects that could have inflicted the bruise. What do you think about that?
Many objects could cause a tramline bruise. A number of objects in any room could cause a tramline bruise. For example, the curved edge of the jury partition or even that lamppost.
Thank you, Dr. Choy. No further questions, Your Honor. May the witness please step down.
Good morning, Ms. Martini.
Good morning.
What do you do for a living?
I'm an actress on the soap opera The Day After Yesterday.
And did you know Mr. Rodriguez?
Yes, I did. We were romantically involved. We dated for about a year in Colorado.
Could you please describe for the court Mr. Rodriguez's disposition?
Well, I would say he was a good person, but he always seemed depressed.
Why do you say that?
He was just so unhappy all the time. He even said things like, "Life is so hopeless. Why go through so much pain?"
Well, Ms. Martini, did you ever see Mr. Rodriguez engage in any self-destructive behavior?
Yes, I did. About 2 years ago in Colorado.
What happened 2 years ago?
Came home from a jog one day to find him unconscious on our couch with an empty bottle of Vicodin.
What did you do?
I called an ambulance, and luckily they were able to pump his stomach in time.
Ms. Martini, how did this incident affect your relationship with Mr. Rodriguez?
Well, it was hard on both of us. I tried to cheer him up, but eventually we decided to move to LA for a change of scenery for him.
Did your relationship change after your move to LA?
It did. We both couldn't find work, and we ended up breaking up soon after arriving.
After the breakup, did you and Mr. Rodriguez ever resume a relationship?
Sometime in spring we became friends again.
Did that relationship ever become romantic again?
No. He wanted to get back together, but to be honest, I had moved on. My career was taking off. He was married, and it just wasn't the right time.
Ms. Martini, could you please describe Mr. Rodriguez's disposition in LA?
Well, despite all of his stardom, he complained about feeling alone and depressed.
Did you see Mr. Rodriguez on the night of October 12th?
Yes, he and Toby came to a party I was hosting at my apartment.
Did you talk with Mr. Rodriguez that evening?
Yes, but we only chatted for a couple of minutes. I was really busy with the party, and I spent most of the night with my new boyfriend.
How did you observe Mr. Rodriguez to be behaving?
He seemed drunk and angry. He even yelled at one of my friends over something meaningless. He was embarrassing.
Thank you, Ms. DiMartini.
Good morning, Ms. DiMartini.
Good morning.
I'd like to direct your attention to your meetings during the springtime, Mr. Rodriguez. Now, the two of you met several times, isn't that right?
Yes.
During those meetings, Mr. Rodriguez talked about Jess, true?
Yes, he did.
Mr. Rodriguez said that Jess was kind of violent, isn't that right?
Yeah, that was Taylor. Yes, he did.
Mr. Rodriguez also said that Jess was scary, true?
Yes, he did.
He also said that Jess was mean, isn't that right?
Yes, Taylor said that.
It didn't sound like a healthy relationship, true?
I don't think Taylor can have a healthy relationship with anyone, no.
Directing your attention to the evening of October 12th, you stated that you spent the time with your boyfriend, isn't that right?
Well, most of the night, yes.
You two were flirting, true?
Yes, we were.
Mr. Rodriguez was there as well, isn't that right?
Yes, he was.
On direct examination, you said he seemed upset, isn't that right?
Yes, he did.
Mr. Rodriguez had approached you about the two of you getting back together, isn't that right?
At the party, no, but previously, yes.
And previously, you had told him that you did not have time for it, isn't that right?
Yes, I didn't want to be in an all-consuming relationship.
Finally, Mr. Martini, back in Denver, when Mr. Rodriguez was self-destructive, he used Vicodin, isn't that right?
Yes, he did.
And Mr. Rodriguez's death was caused by carbon monoxide poisoning, true?
Yes, it was.
Thank you, Ms. DiMartini. Your Honor, no further questions.
Ms. DiMartini, did you know Miss Markson?
No, I've never met her.
Thank you. Your Honor, I'm finished.
Hello, Ms. Rico.
Hello.
What is your occupation?
Well, currently I am an assistant producer for the show Newport Beach.
Do you have a background in the entertainment industry?
Yes, I've been working in Hollywood for the past 18 years, and I've been doing everything from scouting, screenwriting, producing. You name it, I've done it.
Did you ever work with Taylor Rodriguez on set?
Oh, yes, many times.
Have you ever worked with Miss Markson?
Yes, I have. I've been working with Jess in show business for about 10 years now.
Where were you on October 12th? At 10:25 p.m.
Well, I was at Jess's house. She had invited me over, and her friend Alex was there too.
What did you do there?
Oh, we just played some pool, talked about how the new season of Newport Beach was going.
Did Jess mention Taylor?
Yes. Jess made a sarcastic comment about Taylor leaving the show. She also told me that she was concerned with Taylor's career.
What was the concern?
Well, it was a bad choice for Taylor to leave for the movie Blood Rob. Over the past 18 years, I've seen a lot of actors ruin their careers by leaving the movies too soon. Hollywood's a tough place to work in.
Did Taylor Rodriguez ever tell you how he felt emotionally?
Yes, he did. I especially remember one conversation during the season finale of Newport Beach last summer.
Can you tell us what happened?
I went to get Taylor for the shoot, and he wasn't in costume and he looked upset. I asked him what was wrong, and he said that being famous wasn't what he expected.
Did he say anything else?
Yes. He said that the people were so fake and there was no one he could relate to. And that he thought this would have made him happy, but he had never been more miserable.
Ms. Rico, what was your response to these statements?
Well, I had seen Taylor looking depressed before, so I tried my best to comfort him.
Objection, hearsay, and relevance?
Your Honor, this is relevant as it is laying foundation for Mr. Rodriguez's subsequent actions. As to the other ground, she is testifying as to what's rationally based upon her perception. What she remembers, its foundation.
Your Honor, first of all, rationally based hearsay statements are still hearsay. Now, if opposing counsel is merely using this to lay foundation, then the prosecution would have no objection to this being used for that limited purpose.
Yes, your request is granted. Go ahead, counsel.
Yes, Your Honor. Ms. Rico, to the best of your knowledge, did your efforts to comfort him work?
Well, no. Because right after I tried to, Taylor looked at me and told me something that I'll never forget. He said, "I am not sure life is worth living like this."
Thank you, Miss Rico.
Good morning, Miss Rico.
Well, good morning.
Let's begin where Ms. Young just left off. You were talking about a statement Taylor Rodriguez made to you, correct?
Yes, that's correct.
He said that he wasn't sure that life was worth living like this, correct?
Oh, yes, he did say that.
And this occurred in the summer, true?
Yes, it occurred last summer.
So that would be several months before Mr. Rodriguez died, isn't that right?
It was about 3 or 4 months before, yes.
During direct examination, you also discussed your relationship with Ms. Markson, correct?
Yes, that's true.
You've known the defendant for a number of years, true?
For about 10 years, correct?
During the time that you've known the defendant, you say that she's something of a mentor to you, correct?
Yes, that's true.
During direct examination, you stated regarding the jobs that you've had in Hollywood that, quote, you name it, I've done it. Isn't that right?
Yes, that's true.
And in regards to all of these jobs, Ms. Markson is the one who recommends you for almost all of them, correct?
Yes, that's true.
Now, you were at Ms. Markson's home on the evening of October 12, 2005, true?
I was.
You left because you were pretty tired, true?
Yeah, I was pretty tired.
Now, before you left, you had some alcohol, correct?
Yeah, I had a couple beers.
While you were there, Ms. Markson may have made a sarcastic remark about Taylor Rodriguez, true?
She did make a sarcastic comment.
Well, Ms. Rico, you're not entirely sure that she did, isn't that right?
Well, I don't remember the exact phrase, but I do know that it was sarcastic.
You made a witness statement, isn't that correct?
Yes, it's true.
And you were truthful and accurate in this witness statement?
Yes, I was.
Directing court and counsel's attention to page 38, line 44. Jess may have made a sarcastic comment about Taylor's leaving the show. Now, you made that statement, isn't that
Objection, Your Honor. Improper impeachment. It has not been established that this witness contradicted herself.
May I be heard, Your Honor?
Yes.
I asked this witness that she wasn't entirely sure that that Jess Markson made this statement, to which she responded that while she didn't remember the statement exactly, she did know that the defendant made a statement. Now, in her witness statement, she says that Jess may have made a remark. There is a large difference between maybe making a remark and definitively making a remark. This difference is crucial because the defense, in closing argument, will most likely argue that the wind that this witness heard was a reason that Alex Palmer couldn't have heard a fight. Therefore, the perceptions and what this witness remembers about the evening of October 12th are incredibly relevant. Therefore, the difference between may have made and definitively made is important.
Yes. Objections overruled.
Yes, Your Honor.
You made that statement, isn't that correct?
Oh, yes, I did.
So, Ms. Rico, you're not entirely sure what the defendant told you on the evening of October 12th, true?
No, I'm not exactly sure.
Thank you, Ms. Rico. Nothing further at this time, Your Honor.
Miss Rico, does your admiration for Jess Markson in a professional manner at all affect your testimony in court today?
No, not at all. I can't lie here on the stand, and although I've been working with Jess, my opinion of her does not affect what I have to say here today.
Miss Rico, would you be able to get jobs if it wasn't for Miss Markson?
Yes, I would be.
Objection, creating a material fact.
Yep.
Your Honor, counsel opened the door on cross-examination when she asked if she got most of her jobs from Jess.
Objections overruled.
Yes, Your Honor.
You can answer.
Yes, I believe I do. I believe that Jess wouldn't recommend me if she knew that I wasn't good enough for the jobs.
Thank you, Miss Rico.
Good morning, Ms. Markson.
Good morning.
What is your occupation?
I'm a producer, screenwriter, and director.
Ms. Markson, why did you ask Ms. Palmer about hitmen?
I was researching for a new show that was going to be a cop drama.
Directing your attention to Exhibit C, the scabbard found in your house. Who has access to this scabbard?
Well, it hangs as a decorative prop, so I guess anyone could have access to it. But the person who would regularly handle it would be my maid when she cleans my house once a week.
Ms. Markson, how was it that you met Mr. Rodriguez?
We met in a coffee shop in Santa Monica.
Did a relationship develop between the two of you?
Yes. We started dating, and we were married a few months later.
How would you characterize your relationship?
It was loving, and should have been wonderful. We would argue sometimes, and it seemed like nothing could make Taylor happy.
Ms. Markson, how was it that you knew Mr. Rodriguez was unhappy?
He complained about it. In early September, he said, "Everything in my life has gotten so difficult lately. Sometimes I think it might be better if I just gave it all up."
Was that the only time you heard a comment like that?
No. He said many things like that throughout September and October, so I recommended that he see a psychologist.
Ms. Markson, directing your attention to the night of October the 12th, did you and Taylor go to a party that night?
No. Taylor wanted to, and I didn't. We argued about it, and unfortunately I said some mean things. Taylor went out anyway.
When was the last time that you saw Taylor?
At 10 p.m. that night when Toby picked him up.
What time did you fall asleep that night?
I got into bed about 12:30. The TV was on, but I immediately fell asleep.
Did you see Mr. Rodriguez the next morning?
No. I walked by his room to check on him, and it was empty. I figured he spent the night at Toby's house and didn't even learn he had come home until Alex came running in.
What happened when Alex came running in?
She said that Taylor was dead in the garage.
Ms. Markson, what were your first thoughts after learning about your husband's death?
I was shocked. I just wish I could have done something, anything to help him with his depression.
Ms. Markson, did you kill Taylor?
No, I did not kill my husband.
Thank you, Ms. Markson.
Good morning, Miss Markson.
Good morning.
Now, in direct examination, you stated that your relationship with your husband was loving, true?
Yes, it was.
In fact, Ms. Markson, it only started out loving, correct?
It did.
Eventually it became strained, true?
Unfortunately, it did.
You first met your husband in a coffee shop, true?
Yes, I did.
It only took you 1 minute of talking to Mr. Rodriguez to realize that he was a perfect person for your show, true?
Yes, he made a great impression.
Before long, the two of you began dating, correct?
Yes, we did.
You fell in love, true?
Yes, I did.
Ms. Markson, you had never fallen in love like that before, correct?
Correct. Taylor was incredible.
However, despite Mr. Rodriguez being incredible, the two of you would quarrel sometimes, isn't that right?
Yes, as would any couple.
Objection, non-responsive. Move to strike everything after yes.
In response to that?
Your Honor, Ms. Markson was not being non-responsive as she directly answered the question. And the question did not, in fact, ask for a yes or no answer.
May I be heard, Your Honor?
Objection's sustained. Go ahead. Next question.
Yes, Your Honor.
Now, Ms. Markson, you quarreled with your husband on the evening of October 12th, true?
Yes, I did.
And this escalated into a fight, true?
Yes,
Your husband said that he wanted to go out to a party, correct?
that is correct.
And you told Mr. Rodriguez that you didn't want him going out, correct?
That is correct.
During that fight, you were pretty angry, true?
I was angry, yes.
So angry, in fact, that you can't even remember what you told your husband, true?
I don't remember exactly what I said.
You said some pretty mean things, though, isn't that right?
Yes, that's true.
Now, after Mr. Rodriguez left, you invited over a few friends, true?
Yes, I did.
One of these friends was Alex Palmer, correct?
Correct, and the other was Stevie.
Now, Alex Palmer was the same person that you had previously asked about how you could hire a hitman. Isn't that right?
Yes, for a show.
Objection, non-responsive. Move to strike everything after yes.
Granted.
Now, Ms. Markson, on the evening of October 12th, you had some things to drink. Isn't that right?
Yes, I had a beer.
I'd like to talk to you about your professional work. Now, you're a producer, true?
That is correct.
You were the producer for the script Murder by Monoxide. Isn't that right?
Yes, about 5 years ago.
Let's talk about that script. Now, in the script, the spouse kills his wife, true?
I vaguely remember that.
When Mr. Rodriguez died, you were his spouse, true?
Yes, I was.
Two. In that script, the victim dies by carbon monoxide poisoning, correct?
Yes, as well as sleeping pills, I believe.
Objection, non-responsive. Move to strike everything after yes.
Overruled. Go ahead.
Yes, Your Honor. Now, when Mr. Rodriguez died, he died by carbon monoxide poisoning, correct?
Yes, that's what Dr. Stone stated.
Now, in the script, Murder by Monoxide, the victim is found in a garage, correct?
That is correct, I believe.
And Mr. Rodriguez was found dead in a garage, True?
Yes, he was.
Thank you, Ms. Markson. Nothing further, Your Honor.
Ms. Markson, would your relationship with Mr. Rodriguez ever become violent?
No. We may have argued, but things were never violent.
Thank you, Ms. Markson. Your Honor, I have no further questions.
Your Honor, opposing counsel. At the start of today's proceedings, Your Honor made a comment that this courtroom, just like a church, just like a temple, was designed to direct our attention above, to a higher good. Now, that higher good isn't some holy being as it would be in a church or a temple, but instead, that higher good is justice. Justice for the people of the state of California who expect their laws to be carried out with full force. Justice for Taylor Rodriguez, whose life was tragically cut short. And yes, Your Honor, justice for Jess Markson. Justice for striking Taylor Rodriguez with a scabbard. Justice for dragging Taylor Rodriguez's body to the garage. Justice for turning the key, and justice for killing Taylor Rodriguez. Jess Markson, just like everybody else in this courtroom today, deserves justice. A justice which will only be carried out by a guilty verdict. Now, in their opening statement, Mr. McKenzie compared the prosecution's case to a Hollywood drama, but unfortunately, he's a little mistaken. It is not the prosecution whose attempt to dramatize today's proceedings. Remember, Your Honor, it was the defendant who wrote the script to transform the victim into the antagonist. It was the defendant who set the stage for the perfect murder. And it was the defendant who played the lead role on the stand today. It is the defendant who is trying to change today's proceedings from a court of law to another Hollywood production. But, Your Honor, that higher good that you mentioned, justice, simply does not allow us to do this. Now let's take a look at the defendant's cast of characters that she used. First, Stevie Rico, who came to the stand today and during redirect examination said that she couldn't lie on the stand. Your Honor, remember that only moments before, Stevie Rico had directly disagreed with what she said in her witness statement. Remember that Stevie Rico is not only lying on the stand, but that Stevie Rico's mentor is Jess Markson. That Stevie Rico receives almost all of her jobs from the defendant. Stevie Rico could not testify against somebody whom she values as highly as the defendant. What about the other defense witness, Brook Martini, who tried to convince you that simply because Taylor Rodriguez had seen her with another man that Taylor Rodriguez became suicidal? Well, Your Honor, as Brook Martini admitted on cross-examination, she had told Taylor on multiple occasions before October 12th that now wasn't the time to get back together. This wasn't new or alarming information, so it just doesn't add up that Taylor would lash out violently against himself on that particular evening. What does add up is that Taylor would do just as he told Toby Keaton he was going to. Go inside, pack his belongings, and leave Jess Markson forever. But he never got a chance to do that, because when he got inside, the defendant was there waiting. The defendant was there waiting with the sword and scabbard shown in Exhibit C. The defendant struck Taylor Rodriguez in the head only after they began their second fight of the evening. The fight so loud that Alex Palmer could hear from the nearby pool shed. Now, the defense may try and argue that this was simply the television. But, Your Honor, how could this possibly be the television if as Alex Palmer testified, the fighting ended suddenly? The defense's explanation simply does not make sense. What does make sense is that this sword and scabbard shown in Exhibit C caused this bruise. A bruise only 1/80th of an inch in width difference from that sword and scabbard. That is a reasonable interpretation of the evidence. But let's take a look at the unreasonable interpretation. That is suicide. The defense is trying to argue that Taylor Rodriguez became so emotional on that particular evening that he decided to kill himself. Well, Your Honor, they've relied heavily on the testimony of Dr. Choy. Dr. Choy, who told you risky behavior. Now, when Ms. Young asked Dr. Choy during redirect examination why murder wasn't risky, Dr. Choy's only explanation was that by risky, she meant suicide. Your Honor, that doesn't make sense. Murder is risky behavior. Murder led to the death of Taylor Rodriguez. And remember that Dr. Choy testified that somebody consuming a large amount of alcohol would be engaged in risky behavior. Now, on the evening of October 12th, the defendant consumed large amounts of alcohol, as Alex Palmer testified and as she testified during cross-examination. In addition, Your Honor, Dr. Choy has tried to argue that a curved steering wheel could cause that bruise. Now, looking at the circle that she drew on that diagram, it's difficult, but if you look closely, there is a difference between where the bruise hit and where that circle is drawn. It simply does not make sense that a curved object could cause a straight line. The defense has not been able to explain this, just as they have failed to make suicide a reasonable interpretation of the evidence. Now, Your Honor, the prosecution would urge you to follow that higher good of justice for Jess Markson and for Taylor Rodriguez. Do not allow the defendant to transform today's proceedings into another one of her productions. The prosecution isn't making this into a drama. It is the defendant who has tried to do this. It is the defendant who has tried to evade justice. But this courtroom won't let us do this. Return the only just verdict, Your Honor. A verdict of guilty.
The prosecution's closing argument does sound like a fanciful Hollywood script. Possibly titled, Jess Markson and How She Relates to a Greater Good, or Jess Markson, Martyr or Murderer. However, Your Honor, that is exactly what the prosecution's case is. A work of fiction based around 4 unsubstantiated claims, 4 facts, if you will, from which they have drawn unreasonable inferences. Your Honor, the prosecution has taken a wall decoration from Miss Markson's living room and labeled it a weapon. Now, Your Honor, the prosecution would have you believe that this scabbard was wiped clean. And, Your Honor, it was wiped clean by the maid who cleans Miss Markson's house once a week. The prosecution has also taken a half-heard conversation by Alex Palmer and said that it was a fight between Miss Markson and her husband. Now, Your Honor, in order to understand fully Alex Palmer's testimony, it is important to understand Alex Palmer's state of mind. You heard Alex Palmer testify today that she has suffered conviction for assault in the past, that she was on the estate when Mr. Rodriguez passed away, and that she was subject to interrogation by a police officer who was asking her questions. Your Honor, it is understandable that Alex Palmer would want to divert the attention away from herself by exaggerating her statement to the police. It is therefore understandable that mere offhand comments made by Miss Markson became death threats. It is understandable that noises from a television set became screams. Now, Your Honor, how could someone be so cheerful while testifying to death threats? There is only one reason, Your Honor, and that is because Miss Palmer was pointing the finger further and further away from herself. Moving on, the prosecution has taken the bruise found on Mr. Rodriguez's forehead. Now, you heard compelling testimony from Dr. Pat Choy, who testified that the angle at which Mr. Rodriguez's forehead would have come into contact with the steering wheel would have been consistent with the angle of the bruise. Furthermore, as you heard Dr. Stone testify today, pool cues were ruled out of her equation because they would have broken. Your Honor, this scabbard is made of wood. It would have broke or been damaged just like the pool cues. Moving on, the prosecution has taken a Hollywood script found in Miss Markson's storage room. Now, Your Honor, Miss Markson is not the author of this script. It was drafted 5 years ago. It was found in the corner of a dusty old storage room in the middle of a stack of strips bound by a rubber band. Your Honor, without any evidence that Miss Markson has even touched this script in the past 5 years, it is rendered meaningless. Your Honor, the prosecution's entire case is based around 4 facts, unsubstantiated claims that have no connection. A wall decoration, some noise, a bruise, and a television script. Your Honor, there is simply no evidence to substantiate their far-fetched claims. What the prosecution has failed to consider is the fact that Mr. Rodriguez was an incredibly depressed person. No matter what was going on in Mr. Rodriguez's life, whether it was a restaurant job or fame, fortune, and love, Mr. Rodriguez was simply always depressed. You heard Ms. Rico testify today that when Mr. Rodriguez's career was flourishing, he said, "I am not sure,
Two,
that life is worth living like this." You have also heard the testimony from Jess Markson, his wife, who testified that Mr. Rodriguez was a sad and depressed person who had a difficult transition into stardom. She testified that when he finally did become a star, he said, "Everything in my life has gotten so difficult lately. Sometimes I think it might be better if I just gave it all up." The court has also heard the testimony from expert witness, Dr. Pat Choy, who testified that nearly 50% of all people who commit suicide have attempted to commit suicide in the past. Dr. Pat Choy also testified that alcohol is a depressant and that depressed individuals, while under its influence, are more likely to commit suicide. Most importantly, Dr. Pat Choy testified that Mr. Rodriguez had many precipitating events evident in his life that led him to commit suicide.
one,
These precipitating events include Mr. Rodriguez's sudden career change into stardom, Mr. Rodriguez arguing with his wife, and Mr. Rodriguez seeing Brook Martini with another man. Your Honor, despite how wonderful Mr. Rodriguez's life should have been, he could simply not escape his terrible depression. As such, Ms. Markson should be found not guilty. Thank you, Your Honor.
Your Honor, Mr. Goodstein brought up 4 points, so let's discuss each of those. First, a wall decoration. Your Honor, it's true, the scabbard was decorative, but it's also true that that scabbard was only 1/80th of an inch off from the bruise on Mr. Rodriguez's forehead. That is simply not a coincidence. Point number 2, some noise, a fight. Your Honor, if as the defense says that this was simply the television, then why did it end so suddenly? That is not reasonable. Point 3, a bruise on Taylor Rodriguez's forehead. Well, Your Honor, Dr. Choy tried to say that this could have been the edge of this jury partition, that it could have been this lamppost. Are these 2 things only 1/80th of an inch off? Absolutely not. And the script? Your Honor, that script exactly parallels today's case, because the defendant produced that script, just as she tried to produce today's proceedings. Thank you. Time.
Your Honor, opposing counsel has just attempted to confuse the issue that Mr. Palmer may have heard Ms. Markson's television, or he may have heard angry noises. Now, Your Honor, the defense does not know for a fact what Mr. Palmer heard. Ms. Palmer, my apologies. But what is more important is that neither does she. Now, Your Honor, what opposing counsel has outlined in her closing argument is that there are 2 interpretations. What she has failed to consider is that there are 2 reasonable interpretations, one of which
30
points to the defendant's guilt, the other of which points to the defendant's innocence. And, Your Honor, if both of these are reasonable, the law dictates that you must choose that interpretation that points to the defendant's innocence. Your Honor, this is merely the trial of a suicide survivor, Jess Markson, and the man she lost to the disease of depression. Thank you.
This time, having heard the evidence in this case and listened to the arguments on both sides, this court does have a reasonable doubt as to the guilt of this particular defendant. I find the defendant not guilty. Thank you. You're free to go. But you're actually not free to go. You have to stay there for a little bit longer. Ladies and gentlemen, I've been doing this, as Laura was pointing out, probably the better part of 20 years. And like Judge Hernandez, this is really the highlight of my year. I look forward to this so much, and to be invited to preside over the championship round. You people were staggeringly unbelievable. I just have to say it was incredible. And regardless of the outcome, I know this is a competition But as Commissioner Rose said, you're all champions in our view, okay? You really are. This was outstanding in every way. I just want to make a couple of comments individually. Is it Caitlin? Did I get that right? Caitlin, what an outstanding performance. Pretrial, that was just terrific. I threw a couple loops there, and I dropped my voice a little bit, not on purpose, believe it or not. And you responded very, very poised, with a very poised response. And what did you say? That kind of thing. It's okay to ask a judge a question, like that. Oh, wait, excuse me, I didn't hear you right. Or wow, did I really hear that right? So really, really well done. And was it Sarah? Sarah, equally fantastic effort. My goodness, we were bringing up cases and we were going through cases, and you were responding to cases, and so you had a very wonderful command of it. You're very relaxed. I appreciated that very much. Judges like that when people are relaxed and you can hear things clearly, and that's wonderful. And Kimya, did I get that right? Kimya? Yeah, wow. You have a real passion about you and an interest. You really engage the witnesses. That was wonderful to see. A lot of lawyers try to be so kind of distant and they're so worried about the next thing they're going to say, which is a credit to your preparation, but very, very relaxed, and you really engaged every witness. You were right there, not necessarily in the face, but you're on your toes, and that was a wonderful thing to see. Really, really terrific. Thank you for that. And Rachel, I hope I got that right. Yes. Rachel, oh my goodness, Rachel, you're a tiger, and you don't let go, and that fantastic persistence is a really good quality, and you're persistent. Win, lose, draw, you're persistent. You just hung right in there, and fought, and that was very nice to see. Ian. Is it? Ian, I swear I've seen you in court before. Did you get that feeling too, folks? I was thinking, where have I seen this guy? Oh, wait a minute, he's a high school student. That was an incredible performance, and I just want to tell you that that kind of performance comes obviously with preparation, but it comes with certain natural skills too. You have a nice voice, wonderful presence, you stand upright, you don't slouch like I do a lot. And of course, I have a bad back, and I'm old. But you're young and you're energetic, and you can really hear your voice. You're one of those guys that's never going to need a microphone, ever. And yet, it's voice modulation was perfect, and thank you. That was a wonderful, wonderful effort. And is it Kimberly? Kimberly, you're so delightful, and you're the kind of person, an attorney who comes into court, and the judge will say, "Oh, good, we have Kimberly on calendar today, folks," because you're going to be prepared. You're going to be calm. The judge is going to understand, and the jury or whoever is going to really understand what you're saying. But you do it in such a calm way. You can just sort of dice somebody up, and they don't even know it. That's an incredible thing. I mean, people like you are really dangerous. But I mean that in a very positive way, obviously, right? Okay, I want you to take that positively, because it's so. You just have such a warmth about you, and you're so disarming, and that's a really wonderful quality. And I appreciate that very much. And is it Patrick over here? Did I get that right, Patrick? Patrick, you're unfailingly polite. Oh, my goodness. We have entire committees on the bar that are devoted to what, folks? Civility. Yeah, Sharon knows, Ron, Joe, and members of our bar over there also know. Oh, my gosh, we have to raise the bar, folks, in terms of civility. And it's so... I just am so enthusiastic when I see our young people out there, asking for permission, to do this, or standing up and expressing a real concern and a politeness and a deference to the court. It just means so much to us and to the community, and you hang on to that. Plus, you're articulate, you're smooth, nice tie. So you're absolutely terrific, just wonderful. And I'd like to go through all the witnesses. I won't, but thank you, Defendant Markson, now that you're free, and all the other witnesses. You're all in character. You're very believable. I agree with the earlier comment. The experts were just phenomenal, too. You're all in character. I was actually believing you were the people, especially the aspiring actor over there with the jacket. I thought, yeah, I hope you make it. I almost wished you good luck. I said, no, wait a minute. He's still a student, and I thought, oh, my gosh, what am I doing? But as you notice, I got so caught up in it, I kept thinking about recross. right? And, of course, you don't have recross here. But that's how real you made this for us. And so my kudos and congratulations and best wishes to all of you. I'm going to leave you with a thought, okay, real briefly. A couple of things you've learned here, some lessons, I imagine. I hope you carry away with you. One, the courtroom may be the same, the physical plant, right? The laws may be what the law is, the rule of law is, but the judges are different, aren't they? Did you notice that? We're all different. We have different takes on things. We have different personalities. Hopefully our rulings are right around in the same ballpark, but we're all different. And so you need to adjust, don't you? You need to be flexible, all right? That's same as true in life. You need to flex. The other thing that you learned is that this is a new language, isn't it? For those Star Trek fans out there, it's like Cleonese or something, you know? This is a strange language that we have, right? And like anything in life, you know, when you learn the language and you can hear and understand what the other person's saying, it makes life a lot easier, and you can actually start doing some marvelous things with it. The law is complex, isn't it? Quite complex, and you've mastered it very, very well for this event. I congratulate you on that. The bottom line, folks, is that what this is about, this competition is about, it's not just about winning and losing and about, you know, going after a trophy or whatever. It's about relationships. Can you see that? It's about relationships. The case is about relationships, right? Your effort preparing is about relationships, trusting each other, right? Coaching each other, helping each other, right? Your coaches and your teachers supporting you. It's all about relationships. Your parents bringing you to the classes and all that, you know, waiting for you, you know, warming dinner for you at night, you know, when you're getting home late. It's all about relationships, right? And what is it about relationships? I alluded to this earlier, but I'll be more specific. It's about truth, right? Finding the truth, right? That's what this is all about here, right? Relationships, finding the truth. It's about justice, right? We alluded to that in your argument. You know, it's about achieving justice, right? It's about freedom. It's about preserving it. Okay? You see that? And that's about relationships too, all right? And what you all have done, whether you've known it or not, throughout the rest of your life, when you think back on this, you'll think of those things, I'm sure, all right? But I want you to think about this as a relationship builder, a relationship learning experience, to help us all do what we need to do here, and that is to do justice, right? Find the truth, right? And live well with each other, all right? So I want to thank you and congratulate you, and we'll see you this afternoon.